Ladies and gentlemen, if everyone is ready, we can make a start. We will start off.
Can you switch microphones, please?
Okay, you're getting English?
Can you switch to English?
Is that done? Are you hearing every? Yep. Okay. Well, welcome, ladies and gentlemen. We start our second day of hearings. In a moment, I'll invite the Council for El Salvador to make submissions on behalf of the non-disputing party. We'll then move on to the claimants' witnesses of fact. So, Mr. Parada.
Morning, Mr. President, members of the Tribunal. It is my pleasure to be here today on behalf of the Republic of El Salvador as a non-disputing party in this arbitration to discuss the issues of treaty interpretation that were treated in more detail in El Salvador's written submission filed this last Friday. But before going into the substance of this submission, I would like to take a moment to talk a little bit about the role of the non-disputing parties in a CAFTA arbitration. The reason we are here today with an international tribunal adjudicating a claim by foreign investors against a sovereign state is because seven sovereign states, came together, negotiated, signed, and ratified a treaty that we call CAFTA. In more propriety, we should be calling it CAFTA DRUS because the Dominican Republic and the United States are also parties. But in short, I will just refer it to CAFTA. Now, under the Vienna Convention on the Law of Treaties, as well as under customary international law, states are considered to be the masters of their treaties. So the CAFTA parties reserved for themselves a role in the interpretation of the treaty. And they did so because they firmly believe in protecting the integrity and the long-term viability of their treaty. And in this case, they do so by filing non-disputing party submissions under Article 10.20.2 of CAFTA. Now, it is important to note that a non-disputing party does not take sides in an arbitration, does not have an interest in the outcome of a particular case, and does not express an opinion on how the interpretations of the treaty being expressed are applied to the facts in the case. This is because each CAFTA party understands that the treaty must be interpreted in the same manner, regardless of whether the CAFTA party is before a tribunal as a respondent in an arbitration, or as a non-disputing party, or if one of his nationals is before the tribunal as the claimant in the case. Now we'll turn to the main points of El Salvador's submission, and I'm going to touch on 3 points. I'm going to expand on one a little more because this is the first CAFTA arbitration regarding environmental measures that reaches the merit stage. There have been 2 before that ended on jurisdiction. So because in this one, jurisdiction is joined to the merits, I'm going to refer a little bit more about the importance that CAFTA gives to environmental protection. And I will also refer to one issue where there's a specific influence of that preeminence for the protection of the environment on the issue of expropriation. Second, I will speak about the temporal application of CAFTA. And third, I will speak about the concept of fair and equitable treatment as part of the minimum standard of treatment under customary international law. Now, with regard to the environmental protections, as I mentioned, this is the first CAFTA arbitration that reaches the merits that deals with environmental protection. Now, we're here under Chapter 10 of CAFTA, but Chapter 10 cannot be read in isolation from the rest of the treaty. And it is important to note that there's an entire chapter, Chapter 17 in CAFTA, that deals with environmental protection. And there are some provisions that the tribunal may want to refer to later, for example, in Article 17.1, where the CAFTA parties recognize the right to establish their own levels of environmental protection and even to change them, keeping in mind, though, that they have to have a high degree of protection for the environment, and they're encouraged to continue improving that level of protection. Article 17.2 even includes a commitment from the CAFTA parties that they will not subordinate environmental protection to policies designed to encourage investment. So this priority that CAFTA gives to the environment also applies to Chapter 10, the investment chapter. For example, Article 10.11 clarifies that Chapter 10 does not in any way prevent a CAFTA party from adopting, maintaining, or enforcing measures related to the protection of the environment. I would note that in addition to this article, I understand that there is a letter of understanding between the United States and Costa Rica in relation to the specific protection and preeminence of the environment on issues of regulation regarding to zoning and land use. Now, what happens then in the case if there's any inconsistency between Chapter 10 and any other chapter of CAFTA? Article 10.2 specifically says that in the event of an inconsistency between any provision of Chapter 10 with any other provision in another chapter of CAFTA, the provision in the other chapter prevails to the extent of the inconsistency. Now, talking on the specific issue of expropriation, the one thing that I would like the tribunal to pay particular attention is Annex 10C, where the CAFTA parties made it clear that non-discriminatory regulatory actions by a party do not constitute indirect expropriation, except in rare circumstances. If a claimant is going to argue that there are rare circumstances that merit departing from this very strong rule, the claimant will have the burden to prove the existence of these rare circumstances. I want to switch now to the second point, the temporal application of CAFTA. And here there are two very separate and independent issues that need to be considered independently of each other, even in cases like this one where it seems like they converge because of the timing of the facts of the case. One is the non-retroactive application of CAFTA, and the other one is the 3-year time limit to bring claims under CAFTA. Regarding the non-retroactive application of CAFTA, it is clear in the text of the treaty, and as is fully discussed in El Salvador's written submission, that the consent of a CAFTA party does not extend to any measure or any facts, events that happen before the treaty enter into force for each particular party. And I am saying for each particular party because, for example, for El Salvador, the treaty entered into force in 2006, whereas for Costa Rica, it entered into force in 2009. So this is true even if the effects of that measure, of that event, continue after CAFTA entered into force, as would be, for example, in a case of expropriation. So, summing up, there's nothing that happened before CAFTA entered into force that can be a breach of CAFTA because there was no CAFTA obligation before the treaty entered into force. Now I want to speak about the 3-year statute of limitations, or the 3-year time limit to begin a claim. And here it's important to note the exact wording of the treaty. This 3-year time limit begins from the date when the claimant first acquired, or should have first acquired, knowledge of a breach and knowledge that there is damage or harm as a result of that breach. And here there are 3 points I would like to make. The first one is that for the 3-year time limit to begin, it is not necessary for the investor to hire a lawyer to tell the investor what specific provision of the treaty is in breach. It is sufficient for the investor to have knowledge or that the investor should have had knowledge of the measure that is later alleged to constitute a breach of CAFTA. Second, it is sufficient that the investor be aware that there has been some harm or damage as a result of that measure, even if the exact amount of the harm or damage is not known. And third, it is important to know that because of the specific wording of the treaty by the use of the word first knows, or should have known, is that the time limit knows from that time when the claimant first knew or should have known. So the use of the word first in CAFTA means that it is completely irrelevant whether one characterizes the alleged breach as a continuing nature, as an act of continuing nature. Now, with regard to the specific application of this 3-year time limit to expropriation cases, I note that the United States filed a non-disputing party submission this last Friday that I believe would be very helpful to understand how this would play out in those situations. But the most important thing that I would like to leave with you with regard to the second point of the temporal application of CAFTA is that these two issues, the non-retroactive application of the treaty and the 3-year time limit, are completely separate and independent of each other. Now I'm ready to move to the last point, which is the minimum standard of treatment. And here there are 3 main issues that I would also like to mention that are developed in the written submissions filed by El Salvador and the United States this past Friday. The first one is that the CAFTA parties made it clear that in Article 10.5, they were referring to the minimum standard of treatment under customary international law. They also made it clear in Annex 10B that customary international law must be proven through the general and consistent practice of states that they follow from a sense of a legal obligation. In other words, citing arbitral decisions is not how you prove the existence of a norm of customary international law. It is looking at the general and consistent practice of state that they follow from a sense of a legal obligation. And again, under international law, if the claimant alleges the existence of a norm under customary international law, it is the claimant that has the burden to prove the existence of that norm. Second point I want to make in relation to the minimum standard of treatment is that this concept of expectations of the investor, legitimate or otherwise, has absolutely no role in an analysis of whether a state has breached its obligations under the minimum standard of treatment. This has been pointed out in El Salvador's written submission, the United States written submission, and it's been accepted by at least 5 of the 7 CAFTA parties. And the third point in relation to the minimum standard of treatment is perhaps the most important one of all, and I would like to really request your attention on this. In the previous cases that have discussed this minimum standard of treatment, or the concept of fair and equitable treatment as part of that standard, a lot of time and effort has been devoted to the degree of conduct from the state that would breach that obligation. But nothing has been said about something that is even more important, and that is the context, the area of application for each one of these concepts to apply the minimum standard of treatment. So with regard to the level of the state conduct, I would refer you to El Salvador's written submission, but basically under the minimum standard of treatment, because that is a floor for the acceptable conduct of a state, to the extent that that compares to the national treatment that the state gives to foreign investors in regards to internationals. Only very serious and excessive levels of conduct would breach that standard. But what I really want to focus about is on the context in which the minimum standard of treatment can be applied. As the United States and El Salvador noted in its written submissions last Friday, there are only a few areas that have been established and accepted where the concept or the standard of minimum standard of treatment applies in customary international law. And the two parties listed those areas, and there were three. One is expropriation, the other one is full protection and security, and the third one is denial of justice. Well, as you know, CAFTA deals with expropriation in Article 10.7, and full protection and security is dealt with in Article 10.5.2b. Therefore, that leaves denial of justice as the only area that the parties have recognized that applies to this concept of fair and equitable treatment as part of the minimum standard of treatment in CAFTA Article 10.5.2a. So unless and until a claimant can come before a tribunal to prove the existence of another area of application for the minimum standard of treatment under customary international law beyond denial of justice for this concept of fair and equitable treatment, and does so with reference to the general and consistent practice of states that they follow from a sense of legal obligation, the area of application of this concept of fair and equitable treatment in Article 10.5 should be considered restricted to denial of justice. And I would like to make something very clear in this regard. When we speak about denial of justice, we're only talking about actions of the judicial branch of the government, contrary to what you may have heard yesterday. So when Article 10.5 refers to criminal, civil, and administrative adjudicatory proceedings, all these three actions are actions of the judiciary. I think it is clear to everyone that criminal and civil actions are actions of the judiciary, but there might be some question about this reference to administrative adjudicatory proceedings. So I want to make it clear that this reference in English as administrative adjudicatory proceedings, which in Spanish is procedimientos contencioso administrativos, refers to proceedings of the judicial branch of the government. I would really ask the tribunal to consider the non-disputing party submissions on this point. This submission, as you can see from El Salvador's previous submission in the previous CAFTA case that dealt with the merits on Article 10.5, was unfortunately not addressed by the tribunal, which went all the way to make a finding on liability without addressing this issue. And so I would like the tribunal to please review this concept as explained in the non-disputing party submissions. And along these lines, when we're talking about denial of justice, as you know, one of the requirements is the exhaustion of local remedies. So in conclusion, I would like to end by noting that in this non-disputing party written submission filed last Friday, El Salvador attaches annexes copies of the last 4 non-disputing party submissions filed in the previous CAFTA arbitration, in part because El Salvador did not believe that the non-disputing parties would have enough time to submit a non-disputing party in this case because of the short time limit that was allowed. At the time, El Salvador did not know the United States would file also a non-disputing party submission, so I would direct the tribunal's attention to that last submission as a reflection of the United States interpretation of CAFTA. So this concludes El Salvador's presentation, and I would like to thank you for your attention.
Mr. Parada, thank you very much, and thank you to El Salvador and to the United States for their written submissions in this case, and of course we will take account of those very carefully as required under the CAFTA. So thank you very much indeed.
Thank you, sir.
Before we turn to the testimony of the witnesses, which will take up most of the day, as I signaled to you yesterday, we have a number of questions that we would like to put to you now. We will give you an opportunity to respond. immediately if you'd like to do so. We don't anticipate that you're going to want to make immediate and detailed responses, but you may want to make some initial reactions. The questions are of some length, so we've got them written out for you, and also for the assistance of the interpreters and the court reporters. I'll invite the Tribunal Secretary to hand those out to you now. Mr. Cantor will go through the first set of questions, 8 questions, and then I will come up with, will follow him with a number of others. And if in the course of this Mr. Venuesa has additional questions, he will add those. So let me turn now to Mr. Cantor.
Shall we give counsel a moment or two to digest what they've just been handed, or shall I proceed?
No, I think read them into the record. They will follow as you go along. I think that's fine.
Very good, Mr. President. Then I will simply read the questions as written, pause for a moment, and see if anybody wishes me to explain any of the questions that may be less than clear. Claimants have asserted that SINAC, S-I-N-A-C, undertook, quote, measures, unquote, to suspend or continue suspension of expropriation proceedings in relation to the March 2010 Contraloria report, which, quote, measures, unquote, continue to date. Claimants further assert that those, quote, measures, unquote, were either part of a continuing breach or one component of a series of acts or omissions breaching, 1, the customary international law, begin quote, promptness, unquote, requirement for expropriation. 2, the, begin quote, without delay, end quote, requirement of CAFTA Article 10.7.2a. Or 3, the Article 10.5.1 obligation to accord fair and equitable treatment. Claimants also argue that these matters were only disclosed first upon receipt in July 2014 of Respondent's Memorial on Jurisdiction and Counter Memorial on the Merits, paragraphs 84 through 91. Therefore, say claimants, respondents have waived any right to object to claimants raising these matters as breaches, or alternatively, the claimant should be entitled to amend their statement of claim. Respondents reply that the purported, begin quote, measures, unquote, were in reality a, begin quote, lingering effect, end quote, of an earlier expropriation and or predate the time bars in this dispute. Moreover, respondents assert the claimants have not raised the matter in a timely manner. In that light, I would be grateful for further information from both of the parties about this matter, including responses to the following questions. I then list 8 questions. They candidly overlap in some respects. My apologies for the imprecision. First, exactly what conduct was taken by the Contraloria and when? By SINAC and or MINAC, and when? Second, if the matter has resulted in continuation or establishment of a suspension of expropriation proceedings, is there evidence of the expected duration of that suspension? Third, what, if anything, is the impact of this matter for purposes of the time bars at issue in this dispute? Fourth, would this matter have a differential impact as between the direct expropriation claims and the indirect expropriation claims, or not? Fifth, what standard should the tribunal employ to distinguish between so-called, begin quote, measures, unquote, and so-called, begin quote, lingering effects, unquote, of earlier conduct? And what evidence is relevant to determine the category into which this matter should be placed? Sixth, is the assertion by claimants with respect to this matter an allegation of further facts, comma, learned as part of the adversarial process, in support of claims already made by claimant in its statement of claim? Seventh, or alternatively, is the assertion by claimants with respect to this matter a new claim for which an amendment to the statement of claim is required? And last, eighth, do the circumstances in which this matter was disclosed to claimants affect how the tribunal should treat the assertion, and if so, how?
Thank you very much. These are an intricate set of questions, so I don't imagine that there will be an inclination to respond in any great detail. I'll go through the questions that I'd like to put, and then I'll invite the parties whether you'd like to make any initial comments. Just as a prelude to my set of questions, let me caution the parties not to try and read the tea leaves and to try and identify where the tribunal is going. The tribunal does not itself know where it's going at the moment. These are simply questions that have occurred to us on the basis of your written submissions and your opening submissions yesterday. I have 5 questions. Both parties have already made submissions that go in some form to the issues that are raised in the questions. The purpose of the questions is really an invitation to both parties to provide responses that focus more directly on the points of the inquiry. So the first question is, assuming that an expropriation of property is lawful at the point at which it is announced, in the sense that it meets all of the requirements under Article 10.7.1 of the CAFTA, including a commitment to pay prompt, adequate and effective compensation, and provides a mechanism for doing so, does a subsequent failure to pay compensation promptly, or the subsequent payment of compensation that is inadequate or ineffective, constitute a self-standing, independently actionable breach of Article 10.7.1, or does it simply taint the initial act of expropriation ab initio? Second question, assuming arguendo that a subsequent failure to pay prompt, adequate and effective compensation constitutes a self-standing, independently actionable breach of Article 10.7.1, at what point does that breach become actionable in respect of allegations going separately to promptness, adequacy and effectiveness? In other words, at what point can it be said that the alleged breach in respect of a failure to pay compensation promptly, adequately and or effectively crystallized? Third question, in the case of an expropriation, is the breach in contemplation in Article 10.18.1 of the CAFTA, that's the limitation clause, an expropriation contrary to Article 7 of the CAFTA, or is it the conduct amounting to the taking of property, whether or not such conduct was actionable under the CAFTA? In other words, is a claimant's knowledge of the alleged breach contingent on the existence of a right under the CAFTA? Fourth question, assuming arguendo that in the case of an expropriation, the breach in contemplation in Article 10.18.1 is a breach of Article 10.7.1, what impact does the entry into force of the CAFTA on the 1st of January 2009, for purposes of these proceedings, have on the date on which the knowledge of the alleged breach could first have been acquired? And fifth and last question, assuming arguendo that for purposes of Article 10.18.1, the date on which knowledge of the alleged breach in the present case could first have been acquired is the 1st of January 2009, what impact, if any, does this have on the operation of the 3-year limitation period in this case? So those are the questions. Let me see whether Raul Vinuesa wants to add anything to those.
I'm very sorry to disappoint the parties and the president, but I don't have questions now. I will have it probably later on. For me, the positions of the party is quite clear, but it doesn't mean that it couldn't be extra questions later on. But I'm satisfied with what I have read and what I have heard during yesterday. Thank you.
I can't imagine that that amounts to a disappointment to the parties in the light of the questions that we've just given to them. Let me just pause here then for a moment to invite each of the parties, first the claimant, then the respondent. If you would like an opportunity to give any immediate response, and if not, this won't be held against you. You can save these up and respond at a later stage. So, Mr. Copa.
Thank you, Mr. President, members of the tribunal, and we'll hold back our disappointment that we don't have questions from all three members of the tribunal, but thank you very much for these. And they're detailed and helpful. A couple of things arise, though. One of them is that I can confirm that having read the detail of them, I think they would be best honored and responded to in some written form. And so we'll undertake to do that during the course of the hearing. I expect we'll be able to give you written answers to the questions from the claimants before the close of the hearing this week. I promise that without having asked my team members, but we will be able to do that. There is a procedural question that arises out of some of the questions raised by Mr. Cantor that I think we would benefit from thinking about and perhaps addressing from a procedural perspective, because some of the questions he's asked of the state, I think, can't be answered in the context of the current record. And so I think we probably need to think about that. It might be useful to address that briefly this morning or to wait until later in the hearing. If you wanted us to address procedural consequences, I'd need a little bit of a break so that we could caucus and come back and develop that question for you.
Thank you, Mr. Cooper. Before I turn to the respondent, I think probably now is not the moment to break and consider procedural questions. If we have time at the end of today's session after the testimony of the fact witnesses, we may perhaps address those issues then. You made a suggestion which I think the tribunal did not necessarily have in mind, and that is that you would respond in written form during the course of this week. I will invite Mr. Alexandrov to indicate whether he thinks, or whether he would agree with that suggestion, and then we will consider this further and come back to you. I think we were anticipating that these would be questions that would be dealt with in the course of your response on Friday.
Yeah, I'm sorry, just to be clear, we'll deal with them on Friday, but we won't just deal with them in oral form. I think I expect some kind of form in writing. I wasn't suggesting any other submission other than what we'll be entitled to make on Friday.
Mr. Alexandrov.
Mr. President, a couple of quick points. First, we accept your admonition. We are not reading the tea leaves, and it's the unique prerogative of tribunals like this one not to know where they're going until they get there. So we accept that. We strongly object to any submissions in writing in response to the tribunal's questions. This is an oral hearing. The time for the written submissions has gone. The parties have agreed that there is no need for post-hearing briefs. If that is to be revisited, we can revisit it on Friday if necessary, even though as of right now we don't see the need for such briefs. And so on behalf of respondent, we insist that the questions that the tribunal asks be addressed orally during the closing argument. In that regard, my question, which can be addressed later, and it's a procedural question, is whether the time will take to address the tribunal's questions will be time that will count against the party's time, or whether it will be counted against the time for the tribunal, and that question can be addressed later when we're preparing our closing arguments. But to sum up, the most important point is we would like, and we believe that's the only appropriate way, is to address the questions by the tribunal in our oral argument on Friday. And my last point is probably a clarification in relation to Mr. Cantor's questions. The first two questions are factual. That's a point related to the point that counsel for claimants made. Are we invited to address them on the basis of the existing record? If the answer is yes, we obviously will need some time to pull from the record the relevant information and address questions 1 and 2. If we are invited to adduce additional evidence, then that is a very different proposition, and we'll need some direction on how to handle that.
Let me respond immediately with a holding response, and as I say, we can address this procedural issue at the end of today, which will also afford the tribunal an opportunity to reflect both on this procedural issue and also on the question of written submissions. We haven't yet, the tribunal has not yet made up its own mind about post-hearing briefs. That, as we know, is to be addressed on Friday. So it is our expectation at this point that insofar as it's possible to address these questions, that both parties will address them in the course of their oral submissions. I do take the objection by the respondent to the suggestion, if I and indeed the respondent are understanding it correctly from the claimant, that you were proposing to submit a written document rather than, as it were, pieces of paper in response or in assistance to your oral submissions, but we will come back to that this afternoon. Just on the question of whether the time taken in response to these questions is the tribunal's time or is the party's time, I think as I indicated right at the outset when I flagged the possibility of these questions, responses to questions from the tribunal goes to the tribunal's time, not to the party's time. Now, that being said, there is going to be a challenge of timekeeping if you roll up your responses in the course of your concluding submissions. So it will be important that you indicate that you are responding to questions, and it may be that you want to take the response to the questions in a block of time. One of the issues that we can consider on a Thursday afternoon is the allocation of time for the Friday. We have intentionally built in a little bit of flexibility to allow some greater time for response to questions from the tribunal. But we may have to look at the hearing schedule for the Friday just to ensure that we cover all of that ground. So I think we will return to the procedural points.
I have just one matter arising, if I may, Mr. President. I take on board my friend's objection, and so we'll deal with it in oral submissions and trust to the transcriber to read what I'm reading well so that you can have something in writing that reflects what I'm saying to you. So I think at the end of the day, you'll be satisfied that we've answered the questions. To be clear in respect of my friend's question to the tribunal, the claimants do formally object to any introduction of new evidence. In our view, those questions need to be answered on the record, particularly as the claimant submissions made it formally clear that there was no satisfactory answer to those questions on the record. And so we would object to any expansion of the record, particularly as any procedural ability to test any supplemental factual answers is essentially missing from the process at this point.
Mr. President, if I may, there is nothing to object to. I did not make an application to the tribunal to expand the record or to adduce additional evidence. I was simply asking for a clarification and seeking instructions from the tribunal. We are perfectly content to stand on the existing record.
Thank you very much. I understood it to be the case that this was really a question to the tribunal and indeed to Mr. Cantor, but that's something that we will reflect on and we will come back to you at the end of today. Now, I think in deference to, as it were, a change of voice, I propose that we break for 15 minutes. The witness chair needs to be reorganized, screens need to be put up and so on. So we will reconvene in my new American timekeeping, let's say at 25 minutes past 10. Thank you.